Now, without further ado, we'll now begin session 4 under the title Marine Environment and Climate Change. For session 4, His Excellency Lee Jae-hyung, Judge of the International Tribunal for the Law of the Sea, will be the moderator. Judge Lee, the floor is yours.
Good morning, colleagues. It's always good to have a late start. And are we all ready for another wonderful navigation today? Good. So the session this morning is on marine environment and climate change, one of the hottest topics of the day. And let me start by thanking to the organizers of this wonderful event, Ministry of Foreign Affairs of the Republic of Korea, ICLS, and the Korean Society of International Law. So this year we are celebrating 30th anniversary of the entry into force of UNCLOS. So we are talking about basically numbers as well as history. And I know many of the lawyers are not on very good terms with numbers, but I'd like to challenge you with some numbers. So first of all, do you remember when the request for advisory opinion from COSIS was made? Of course, you are just being modest. So it was December 12th of 2022, right? And December 12th, does it ring a bell to you? To any incident? Yeah, of course, in Korea, we are all aware of the night of December 12th in our journey to democracy, but on a more global level. December 12th is the birthday of the Paris Agreement on climate change. So I do not know whether the coaches timed the application for advisory opinion with this specific date or not, but it is quite meaningful. And do you also remember the birthday of UNCLOS? Yes, it was December 10th. So December 12th, December 10th, yeah, we are originally very close to each other. And it took some years for us to reach a meaningful connection, yeah? Okay, and how about the date that the oral proceedings of this advisory opinion case took place? When did it start? It was 9/11, September 11th. So it was a distress signal of the planet Earth, which rang for more than 2 weeks with the participation of close to 40 states and intergovernmental organizations. So the emergency bell rang, and we heeded to this emergency. We can no longer go along the path as usual. Now the last one. So when was the advisory opinion came out? When did the advisory opinion come out? Right, yeah, 21st of May. And 21st of May, it took me some time to find any meaning to 21st of May. But I did my own research and finally found out. In 1927, it was the date of the first non-stop flight from New York to Paris was made by Lindbergh, Charles Lindbergh. The reason that I talk about this incident is it's a historic event that took 33.5 hours, actually. In the past, it took much longer than what it takes today. And it was finished on 21st of May. It was the date the dots between Europe and North America was connected. They were connected. And the dots between law of the sea and the international law, international environmental law, were connected on May 21st, almost 100 years later. Of course, we had lots of talks about the interrelationship between law of the sea and the international environmental law, but I believe the advisory opinion was the culmination of all these talks. ICLS was able to connect the dots between the numerous provisions of UNCLOS, especially in Part 12, with climate change science as well as climate change regime. And we expect to see a similar result in the other two advisory opinion proceedings in International Court of Justice as well as Inter-American Court of Human Rights. And we also would like to see how it will have impact on potential contentious cases, not only on international level, but also in domestic level. As you must be already aware, there are more than 2,000 climate change-related litigations all around the world. And I'd like to see how it will have impact on those litigations. And also, it is my wish to see that it will have a positive impact on the ongoing climate change negotiations too. And I hope our panelists will touch upon and list some of these aspects. So, without further ado, I'd like to give the floor to our first speaker, Professor James Harrison. Professor James Harrison is Professor of Environmental Law in the University of Edinburgh. And I do not want to go into the details. You can just refer to the descriptions in the booklet. Professor Harrison, the floor is yours.
Thank you very much. Good morning, everybody, and can I join our chair by thanking the hosts for the invitation to speak and their kind hospitality. It's been a real pleasure to be here in Seoul participating in this event, and I hope that I can make a small contribution through my observations this morning to the rich and rewarding discussion that we had yesterday. The topic of this panel, as has been introduced, is the marine environment and climate change. And a lot has happened in this field since the convention entered into force 30 years ago. I've chosen to focus my presentation on marine protected areas because I see them as being emblematic of how the law of the sea in this area has developed to recognize the importance that needs to be attached to the protection of the marine environment, the connections with climate change, but it also is a topic that illustrates the variety of mechanisms through which the law evolves. Systemic and evolutionary interpretation of treaty texts, the ubiquity of due diligence and the challenges of giving that concept meaning, the role of so-called soft law in international environmental law, the relationship between global and regional regimes, and the negotiation of new implementing agreements to give effect to UNCLOS. MPAs can tell us something about each of those themes. And so I want to use marine protected areas as a lens to explore some of these different issues and to reflect on past 30 years of development in this field. There's one more reason to talk about MPAs. In a world where you open the newspaper and you're met daily with quite distressing stories about a range of matters, but including on our impacts on the marine environment, MPAs offer a beacon of hope, a way of telling positive stories about how we can effectively protect the oceans. And I just want to give you one small example to begin close to my home, where I come from. This is Lamlash Bay on the Isle of Arran on the west coast of Scotland. And it's well known in Scotland because it is the location of our only no-take marine protected area in the entire country, which was the result of years of campaigning by the local community to gain better protection for their marine environment as they saw it. It's hard to tell from the picture, but beneath the waves there is a rich tapestry of marine ecosystems, including particularly important seagrass beds that are key to the protection. This site was first designated in 2008, and it's now part of a broader South Arran Marine Protected Area. And there's been research done over the past decade, which demonstrates that there are nearly 4 times more king scallops in the no-take zone since the research began. Legal-sized lobsters are also 4 times higher in the no-take zone compared to adjacent areas. There's additional evidence of species spillover into the surrounding areas, and the studies indicate increasing habitat complexity within the no-take zone. It's an incredibly powerful and positive story for what marine protected areas can do for our oceans. But of course there are challenges too. And what I want to explore in the presentation is how the international legal and policy framework can either help or hinder states' efforts to use marine protected areas and to save the marine environment from the range of threats, including climate change, that we are facing. This is how I intend to proceed with my presentation. I'll start with a few relatively brief definitional points about what a marine protected area is and how it relates to other concepts. I'll take a brief tour through the development and international policy framework in this area, because that provides an important backdrop to the legal provisions. And then I'll focus on a number of key legal instruments and how they can be understood to facilitate the establishment, management, and enforcement of marine protected areas by states, and also some of the challenges that arise in practice. And so in that context, I will look at UNCLOS, the Convention on Biological Diversity, regional seas bodies, and moving out beyond national jurisdiction, considering some of the implications of the still fairly recent BBNJ agreement on biodiversity of areas beyond national jurisdiction. But let's start with some definitions. For a long time, there was no single definition of a marine protected area, and it's the BBNJ agreement really that has pushed towards a clearer conceptual understanding of what this term is. I don't want to labor the point here, but the BBNJ situates marine protected areas as part of a broader range of what are called area-based management tools, or, because everybody involved in BBNJ loves their acronyms, ABMTs. Marine protected areas can be differentiated from this broader category because of their focus on the specific long-term biodiversity conservation objectives. In other words, the starting point for marine protected areas is identifying the features we want to protect and then trying to understand what measures we need to take in order to offer comprehensive long-term protection. There are a range of other area-based measures that states can take that have a slightly different starting point, where the start is often the activity, be it shipping, fishing, aquaculture, and then trying to understand how we can regulate that activity to protect a particular area or a particular habitat or species. But such sectoral measures tend to be more limited in the type of protection they offer, which is why marine protected areas are often pushed as the better, more coherent and comprehensive solutions to area-based management tools. Having said that, both the policy texts and the legal texts that we're about to look at often have these two terms side by side. And actually, the legal framework doesn't necessarily distinguish strongly between them. The other key point to make in terms of definitions, and probably the more important one, which allows us to address some common misperceptions about marine protected areas, is that the level of protection they offer often differs. There are a number of different variants of marine protected areas, and what we have on the slide, for those of you at the front who might be able to see it, is the IUCN classification system, which lists 6 different types of marine protected areas, starting at the top with those that are strictly protected, in which extractive activities are deemed to be incompatible, and so essentially they are spaces in which human activities are removed completely. But going down the table, we see other variants of protected areas, but areas in which activity is permitted, provided it's compatible with the conservation objectives. And just zipping back to the BBNJ definition, you can see there that the definition may allow, where appropriate, sustainable use, provided it's consistent with the conservation objectives. So the definition within the BBNJ agreements and many other instruments I'll be talking about encompasses this whole range of different MPAs. To paraphrase George Orwell, all MPAs offer protection, but some MPAs offer more protection than others. One reason it's interesting to think about MPAs in the context of a conference on the past, present, and future of the law of the sea is that they're, of course, not mentioned in UNCLOS at all. They have emerged, though, as an important policy and legal concept in the 30-year period since the conventions entered into force. In fact, it's just before the entry into force in 1992 at the Rio conference where MPAs make their first major debut onto the international policy agenda in the plan of action agreed at that conference, Agenda 21. And here we see reference to states should identify marine ecosystems exhibiting high levels of biodiversity and productivity and other critical habitat areas and provide necessary limitations on use in those areas through inter alia designation of protected areas. And it goes on to list a number of priority areas which states should consider doing this. And in the intervening period since Agenda 21 was adopted, we've seen a number of international policy commitments getting increasingly more specific in terms of the targets that are set. So in 2002, in the Plan of Implementation from the World Summit on Sustainable Development, we see the inclusion of a target date for states to introduce representative networks of MPAs, 2012. In 2010, we see the Convention on Biological Diversity Strategic Plan, including its Target 11, which sets a quantitative target of 10% of coastal and marine areas to be effectively and equitably managed, so adding further qualitative conditions to the nature of protection that should be offered. And that commitment to at least 10% of coastal areas and marine areas being protected by 2020 is repeated in the Sustainable Development Goals. Now, the more observant of you will realize that 2020 is well past. So how did we do? Well, not so well. The Global Biodiversity Outlook summed up the progress as follows. The proportion of the planet's land and oceans designated as protected areas is likely to reach targets for 2020 and may be exceeded when other area-based measures are taken into account, as well as future commitments to do it. But progress is more modest in ensuring that protected areas safeguard the most important areas of biodiversity, are ecologically representative, connected to each other, as well as to the wider landscape and seascape. This target has only been partially achieved. So a report card that essentially says, try harder. The current target we have in the 2020 Global Biodiversity Framework ups the challenge. We're now aiming for at least 30% of terrestrial and inland water areas to be covered, and marine and coastal areas to be covered by MPAs or other area-based management measures by 2030. And it repeats the importance of those being effectively conserved and managed, as well as broader commitments to integrating them into the wider landscapes, seascapes, and the ocean. Several key points to make about this target before I move on to the actual legal framework. It obviously represents a significant jump from 10% to 30%. This is going to be challenging for states. Secondly, this is part of a broader package of commitments in the Global Biodiversity Framework, all of which are interrelated. And so marine protected areas can be understood as being related to several of the other biodiversity targets relating to marine restoration, relating to climate change. And I think we need to see it as a package of measures to understand its full implications. But finally, it's not a legally binding target. It is a political commitment. Now, that doesn't mean it has no normative force. In many ways, its simplicity, 30 by 30, has an attractive rhetoric which drives many state policies on this matter. Again, in my own jurisdiction, we talk much more about the 30 by 30 target than any legal instruments underpinning it. But I think it's important to think and understand how the law relates to this and how we can use the law to help states achieve these broader policy commitments. Which takes me to first, am I running behind? The first of my legal issues to address. Whilst UNCLOS doesn't explicitly mention marine protected areas in such terms, it does in many ways contain provisions which encourage states to take area-based management measures. And this is most clearly found in Articles 192 and Article 1945 of the Convention, which refer to broad obligations to protect and preserve the marine environment and to take measures which are necessary to protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, or endangered species and other forms of marine life. We've learned a number of things from the jurisprudence that's emerged in the last few years, and particularly the last decade, on how we should understand these obligations. Firstly, the breadth of these obligations, and it's been emphasized by courts and tribunals that Articles 192 and 1945 apply to all maritime zones, and it's even been emphasized that they can apply, in the words of ICLS in its climate change advisory opinion, beyond maritime zones, by which I think they meant within internal waters, a point also made in the Coastal States Right arbitration and the South China Sea arbitration. That's important for marine protected areas because it's often at the interface of the land and sea and estuarial waters, coastal waters, where we find some of the richest habitats. So to have an obligation that applies to all marine waters, even if they're within baselines, is an important understanding to help states move forward on this agenda. Another key takeaway from the jurisprudence, of course, is that these are due diligence obligations. Due diligence is a concept that is used across international environmental law, and it's one that has received a lot of judicial attention in the past years since the ICJ in pulp mills gave some useful clarifications, and that's been developed also by the Seabed Disputes Chamber, and most recently by ICLS and its climate change advisory opinion. Due diligence is, on one level, a useful concept. It's broad, it's general, it can be applied to a range of scenarios, but its ambiguity is also its downfall. There are a couple of key points, I think, where the jurisprudence helps us give a bit more concrete content to this character of obligation, though. It clearly doesn't set a single standard for all states to apply. Its very idea is to be a flexible, or in the words of the Seabed Disputes Chamber, a variable concept, allowing us to take into account a range of different factors, from the manner of the threats that we're trying to address to the resources and the capacity of the state to respond to those. States have choices to make. There is discretion, but it is a bounded discretion. And for me, one of the most important findings on this issue is from the recent climate change advisory opinion, where the tribunal says that due diligence obligations require objectively reasonable approaches to be taken on the basis of the best available science. And that idea that there is a standard that can be applied and assessed by a court is a really important one. This is not a completely subjective standard for each state to make it up as they go along, but we can have a conversation about what reasonable measures can be taken, and we can make an assessment on that basis. The other key point made by the tribunal in its advisory opinion was the need for an ongoing duty to review the evidence, particularly when it comes to the manner of ecosystems and their characteristics. The tribunal explicitly makes reference to the need for review by states, to review the evidence and to use the most up-to-date scientific evidence to design their MPA networks. Finally, it's been emphasized that particularly these provisions in Part 12, but Part 12 more generally, needs to be understood and interpreted by reference to the wider body of rules in international environmental law, this idea of systemic interpretation. And it's in that respect that we need to look beyond UNCLOS and other developments to understand what a duty of states to establish MPA networks might look like in practice. The Convention on Biological Diversity, adopted in 1992, is probably the most important instrument in this respect. It explicitly deals with protected areas in Article 8 and provides that each contracting party shall, as far as possible and as appropriate, establish a system of protected areas or areas where special measures need to be taken. This general obligation can be read in a similar way to UNCLOS as a due diligence obligation. What's important in the context of the CBD is that the legal text itself is really just the tip of the iceberg. And the CBD has two characteristics that are very familiar for international environmental lawyers, but are frequently used to help give more detailed content to these general obligations, and that is the use of so-called soft law to develop guidelines to help states implement the treaty, and the creation of institutional arrangements to oversee those arrangements. And these two techniques have been used extensively in the context of marine protected areas. The Conference of the Parties to the CBD has developed a wide range of guidance to help states give effect to Article 8 of the Convention. Much of it has been adapted particularly for a marine context. This ranges from scientific guidance to states for designing representative networks to detailed guidance on the methods and processes for establishing such networks, encouraging multi-stakeholder processes and transparent governance frameworks. It's also encouraged environmental impact assessment to be applied whenever an activity takes place within a protected area, and it's emphasized the need for effective enforcement. Now, these are non-binding instruments. We can't insist on compliance by states, but they can still provide a benchmark to allow us to have a conversation about what due diligence might look like. And that's both due diligence under the CBD, but also through a lens of systemic interpretation, these sorts of instruments, which it must be remembered are adopted by consensus, and all of the parties to UNCLOS are also parties to the CBD, can be helpful in understanding how a due diligence obligation might be understood under UNCLOS itself. I'm clearly pointing my clicker at the wrong thing. The other institutional arrangement that's happened under the CBD is the development of guidance on ecologically and biologically significant marine areas, but also the development of regional workshops to actually identify what those areas are. This has been particularly important in areas beyond national jurisdiction, where the framework and the actors involved are much broader range of actors. And the CBD process for establishing EBSAs has been a way of bringing together the relevant members of the international community to identify which areas might deserve protection. Now, it's important to understand that the EBSA process is not one about establishing marine protected areas. Most of the documents concerning EBSAs have this disclaimer that the application of the criteria is a scientific and technical exercise. Areas found to meet the criteria may require enhanced conservation and management measures, and this can be achieved through a variety of means, including MPAs, but it's not the role of the CBD to do that exercise. Nevertheless, what the CBD has produced is a really useful repository for areas where we can start considering what protection might be needed. And it's in that context where the newly negotiated BBNJ agreement might become important. Many of you will be familiar with the BBNJ agreement, and many of you were there involved in the negotiations. This instrument was designed to deal with various gaps in the international legal framework. And in the context of area-based management tools, it was the fact that existing sectoral and regional processes were insufficient to provide coherent protection to marine ecosystems beyond national jurisdiction. The BBNJ agreement provides a new legal framework for this to happen, and it sets the objective of the establishment of a comprehensive system of area-based management tools with ecologically representative and well-connected networks of marine protected areas. Of course, it's not in force yet, and that's going to be the first key step to make this an effective framework. But it's also important to recognize that it's very process-orientated. There's nothing in the agreement itself which offers more protection to areas beyond national jurisdiction, and it will rely upon states to bring forward proposals and reach agreement on measures that need to be taken. Nevertheless, it's been identified by a number of states that this new agreement, if it can be brought into force in time, can play a key role in supporting the delivery of the 30 by 30 target that we mentioned earlier under the Global Biodiversity Framework. But there are challenges in giving effect to this new framework. There's an elaborate process set out in the agreement, which determines how a proposal should be considered and encourages wide stakeholder participation from a range of actors, non-state actors as well as states. But it's the end of this process, the COP decision, that I want to focus on in my final thoughts. As many of you will know, there was different views during the negotiations about whether this new agreement should be a top-down system with a COP able to decide on establishing MPAs and designating management measures, or a bottom-up system which was focused on coordination. Arguably, we've landed closer to the second of those models than anything else. And this is apparent if you look at the powers of the COP relating to the establishment of MPAs and management measures. The principle that guided the negotiations on not undermining is embedded very strongly in Part 3 of the agreement, which requires the COP to take measures that don't undermine existing instruments and to respect the competence of other bodies. It can only take measures that are compatible with those adopted, and it can only take measures in cooperation and coordination with those. Where there are other agreements, it would seem that the role of the COP is really to make recommendations and encourage action by existing sectoral or other bodies. And critical to giving effect to this arrangement will be the design of effective consultation mechanisms between the COP and all these existing bodies. How that happens is still to be determined, and much will depend on the parties themselves and who is at the table. Arguably, it could be done through a range of bilateral arrangements between the COP and various international institutions that have a relevant competence. But we could also be looking at other models, and in a sense, the EBSA regional workshops that I mentioned earlier could be a useful model for thinking about how coordination between relevant actors, including existing international organizations, can happen. And arguably, this coordination shouldn't just be happening at the end of the process when the proposal is on the table. Real coordination needs to start early on, and coordination should ideally be happening even before the measures have been brought before the COP. All of this is obviously still to be worked out. And whilst the BBNJ is a welcome addition to the legal framework that we've seen developing over the last 3 decades, we shouldn't celebrate too soon before any actual protection to the ocean has been achieved. Let me sum up with some concluding thoughts. Through a lens of systemic interpretation, it's possible to argue that states have duties these days to establish marine protected areas, but it's due diligence that drives those duties. Significantly in this context, we need to understand what due diligence might look like, and that's where the non-binding instruments and guidance developed by bodies such as the CBD can provide useful guidance, even if we can't insist on complete application of those in all circumstances. Arguably, it is the institutional processes, the forums that bring states together, that are most critical here, to increase learning, to increase engagement, information exchange, and to promote mutual accountability, to help states work together and cooperate in order to achieve the targets that they've set themselves for 30% of the oceans to be protected by 2030. Thank you.
Thank you very much, Professor Harrison, for your very comprehensive presentation on MPAs.